afternoon.
Then it will be.
That is what I am saying. Come basic area side of no more idea. Next occasion we can buy in the here.
So this is what we do every day.
विश्वास करते हैं बोलो अपने क्या बोलो Good morning, sir.
Here we've done something more something. I was very attached to it. Would you be work for 3 years? No. So you don't contain that.
The main list.
This हो गया
Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
May it please, Your Lordship.
Yes, sir.
In fact, I was having a dispute with the respondent number 4, which is the Darbar of Limekura village.
Darbar of?
Limekura village. there is a plot of land which is used as a football field or a playground where we allow the village people or the local people to use it from time to time with our permission. Now, throughout the years, we have been giving the permission to Dorbashnong and they have been using it.
Who are we?
I am the landowner.
You're the
I
landowner.
have inherited from my grandfather, and the area in that place is a Rikinti land, private land, not rewrite land or community land. So Dorbashnong don't own land per se in this area. And an issue arose when the Dorbashnong start giving it for trade fairs and start doing it for commercial purposes, earning huge amount of money. I objected from time to time. And an occasion arose where I have reported before the Deputy Commissioner, because the Deputy Commissioner starts issuing permission because of this COVID scenario and all these things. We take permission for holding big programs. I objected, and one fine day, the Deputy Commissioner issued Annexure B. Annexure B is a letter where it has decided that status quo be maintained on the playground, and that the redressal dispute should be decided by respondent number 4 and 5. When I'm having a dispute with respondent number 4 and 5, how could the Deputy Commissioner give that power to the respondent number 4 and 5? Being aggrieved by that letter at Annexure B, I had filed a writ petition saying that the Deputy Commissioner could not have issued this letter because the Deputy Commissioner, how could it issue a status quo order?
Does the Dorbashnong have the power to decide such a dispute?
No, Your
pertaining to land?
No, Your Lordship. And I'm in dispute with them. Then instead of not touching the matter at all, issued this letter at the behest of someone, which I will not spell it out. Now, being aggrieved by that letter issued by the Deputy Commissioner, I had filed a writ petition before this Honorable Court, and the Honorable Single Judge was pleased to, after hearing the Government Council, was pleased to stay the operation of that letter pending disposal with the writ petition. Thereafter, the respondent number 4 and 5 file a miscellaneous petition under Article 226 Clause 3 for vacating the interim order passed by the learned single judge on the ground that I have suppressed material facts. The material fact that I have suppressed, according to them, is that I had my grandfather had donated this land to the municipality. Now the point here, Your Lordship, I have no dispute with municipality or anybody. Government authorities are not claiming this plot of land. I am the owner.
Number 4 is a Dorbashnong. Number 5 is?
The headman, the chairman of that.
Okay. Municipality
No,
has
they are
never
not in the
claimed.
picture. My grandfather had donated a plot of land which is contiguous to that football field. Now the issue, Your Lordship, that being aggrieved by the single judge order, vacating that interim order granted earlier, I have come before this Honorable Court. Your Lordship.
Who's appearing for number 4?
I'm appearing.
And 5?
I'm appearing.
You're appearing for both of them. Who's appearing for the state?
I'm appearing, my lords.
You don't take any stand, do you?
Stand as well as that the letter which was under challenge before the learned single
Has
judge.
been issued by the Deputy Commissioner, therefore the state.
Therefore, the
The
state.
ideal thing would be that in proceedings under 226 we can't go into title.
Yes.
We can't go into title.
My lords.
So we'll relegate him to the District Council Court and we'll restrain all parties from using the land in question till such time that the issue is resolved.
Much obliged.
And what we will do is, we will require the District Council to resolve the issue, District Council Court,
Yes.
that he approaches. We'll give him 4 weeks' time to approach that court, and we'll request the relevant District Council Court to resolve the dispute within a period of, let's say, 6 or 8 months. And for this time, no one will use that.
Lordships, the state has only one stand, my lords,
Yes.
which we had made very clear before both the courts, that this land is used by the public for sports and so on. The youth uses it.
Yes.
Now, if they're not allowed to use that property, that will create some sort of an effect. And number 2, it's also used for trade fairs. Trade fairs is not really all that important.
Then you acknowledge his ownership. Then thank him for his generosity, and then use it. But just because he is being generous with his land does not mean that you claim ownership over it and he has nothing.
Yes.
Lordships, as far as we are concerned, all this while we were dealing with the Dorbar, that's the correspondence on record. The Maori clan has come in only till recently. That's the only difficulty. So that issue will have to be decided who has title, who was originally using this property. In fact, the correspondence would show that the Maori clan has been representing this
Now
matter with the Dorbar.
show us, we will go into a prima facie assessment of title.
Lordships.
Now show us that the Dorbar has title.
That we don't have anything on record. My lords.
All right.
It is a title dispute clearly.
Yes.
We are only concerned with the usage for the time.
You tell us, how does the Dorbar
Yes, my lord, with due respect to my learned senior, my lord. This land, my lord, that is just on the way to Joy, my lord. Just in the main, near the fire brigade, opposite to fire brigade. Lord. That is called also the fire brigade.
that fire brigade,
Yes.
that triangular plot.
Right.
Yeah,
Now, my
the-
lord, this plot of land, my lord, since time immemorial, my lord, this has been used by the public. And very recently, it is very recently, my lord, the petitioner, my lord, here, the appellant herein, my lord, who has put forward a claim over this plot of land. Otherwise, my lord, if we go through the entire record, my lord, there is not even a single document which to prove that she is the owner of the land, my lord.
No. You see, there's a problem in that. Someone is the owner. Someone has to be the owner.
Yes, ma'am.
Title cannot evaporate.
Right.
Title can go only by adverse possession.
Yes.
You do not claim adverse possession
My
over
lord, I
here.
have been in possession since 1935.
Maybe, but it is not adverse possession.
Yes.
Adverse possession is not passive possession. Adverse possession is something more than passive possession.
I agree with that suggestion, Your Lordship. That
Then allow the sports activities to go on, but don't allow any business activities.
yes, Your
We
Lordship.
will
We'll
restrict
give permission
business
for that.
My only submission.
We will allow, Your Lordship.
Now, my lord, the appellant herein, my lord, very recently has come forward and put a claim, my lord, over the plot of land. This land, my lord, has
You
been,
show us that you have title.
my lord, this land, my lord, I will go through, I will take you, take your lordship through the,
Title is not letter.
yes,
Title is not letter. Title is something more than letter.
Right.
Show us you have title.
my lord, I am also not claiming to be the owner of this particular plot of
Then-
land. My lord, what I am saying, my lord, this particular land, my lord, this was way back in 1935, my lord, this has been donated to Shillong municipality, my lord. Thereafter, my lord, we have come into picture.
So show us the donation.
Yes, my lord, it is there. My lord, may kindly come to page number 98, my lord.
98.
Yes. My lord,
But how does this identify the land?
this is the exact plot of land, my lord. That is the only place, my lord.
He says in front of Swiss Cottage.
Yeah.
Yes, that is in front of Swiss Cottage. My lord, that is the ground, my lord.
No.
Yes, exactly, my lord.
Ours is a different plot of land.
No, exactly
Opposite
not.
Swiss Cottage. That is still a park. It's still a park right now also.
That is wrong statement, my lord.
There's a
Where
park.
is that? No, get us the local plan. Get us the revenue record showing the plan of the area. If there's another plot, and if he's saying that it has to be a question which has to be left to be adjudicated.
Yes,
So show us, get us the plan.
it's not on record, my lord.
You
If,
will not have.
No, you get us the plan. We are asking you to get us the plan. We'll pass an order to that effect.
we'll try to.
You get us the plan. If you can demonstrate to us that yes, this has been donated because this appears to be offer acceptance over.
Yes, my lord. Right.
So then you seem to be on firmer ground. Otherwise, if there is a dispute, then as he has agreed, park will remain park. He will not touch it.
Right.
Where is there any monument?
My lord, that is the circle that when we turn towards the Limekra side, my lord, when we come from Joy.
That's not the Swiss cottage. Yeah? The Swiss cottage
Is there any monument within this park?
Monument, my lord, I have to find.
Monument in memory of Reverend Yumong Lingdo?
Yes, as per the.
Have you called it?
My lord, I will.
Have you called it Yumong Lingdo Park?
No.
My lord, I will just confirm, my lord, as far as this point is concerned, my lord.
Those are the conditions.
Right, my lord.
Is there any monument in memory of Reverend Yumong Lingdo?
My lord, I will confirm.
Confirm that.
Yes, ma'am.
Otherwise, what we'll do is we'll do what the district council court will decide.
Yes, my lord, that is a
But-
civil, yes.
Sporting activities can continue, no business activities.
Right. My lord, may kindly give us some time, my lord, I will try to find out.
The matter pertains to a triangular plot of vacant land.
No. Not a triangular plot, Your Lordship.
Almost triangular, my lord.
It is triangular.
Triangular.
There's Bethany Hospital to that side, there's Justice Tankyu's house to the left,
Right, my lord. Yes.
and there's the fire brigade to the right, and a petrol pump over there.
And a park on the
Park in the thing.
eastern side.
Yes.
Triangular.
The matter pertains to an almost triangular plot of vacant land at what is known as the Fire Brigade Crossing in Laipmukra. Full stop. Paragraph. The appellant claims to have inherited the land from his grandfather and protests the issuance of a letter by the Deputy Commissioner requiring the appellant's claim to be adjudicated by the very Darbar Shnong and its headman who are contesting the appellant's claim to the land in question. Full stop. Paragraph. On behalf of the Darbar Shnong and its headman, comma, the respondent numbers 4 and 5 herein, comma, it is submitted that as early as in 1935, comma, the relevant plot of land was donated by Mon Lingdo to the Shillong municipality on condition that if it is converted into a park, it would bear the name of Reverend Mon Lingdo Park, and that the heirs of Lingdo would have the right to erect a monument in his memory in a corner of the land. Full stop. Paragraph. However, comma, the land is not suitably identified in the letters exchanged between Lingdo and the municipality in 1935, and it is submitted by the appellant that the land that is referred to as open court, the piece of vacant land opposite Swiss Cottage, close quote, in Lingdo's letter of March 11, 1935, is a completely different parcel of land, whereat a park already exists.
Yes.
Full stop. The respondent numbers 4 and 5 claim that the land that was donated by Lingdo to the municipality is the almost triangular plot of land at the heart of the relevant crossing, which the Darbashnong has been in possession of for nearly 80 years. For more than 80 years. Full stop. Paragraph. Disputes as to title to land cannot be conveniently addressed or adjudicated in summary proceedings under Article 226 of the Constitution of India, which is, generally, decided on affidavit evidence. Full stop. The parties will have to be relegated to an appropriate forum where the title may be decided in accordance with law. Full stop. However, during the interregnum, the use of the land will have to be monitored, and for such purpose, the respondent numbers 4 and 5 are requested to produce any material that would demonstrate that the land donated by Lingdo in 1935 is the same land that the appellant now seeks to lay a claim to. Full stop. Paragraph for such purpose, relevant revenue records or municipality maps of the area may be produced. Full stop. Let the matter appear a fortnight hence.
Lordship, I have a suggestion. The appellant also may assess.
Full stop. It will also be open to the appellant to rely on whatever records that may be available with the appellant.
Yes.
That the appellant may be able to bring.
Much more. Also, there is a mention that the land located at Limekura, before Limekura, it has to be written Lomori. Lomori, Limekura. Much obliged, Your Lordship. Your Lordship, a small prayer, because the main writ petition is pending before a single judge, and this order is creating a problem for us. If it can be just stalled for the moment.
Nothing will happen. Matter is pending before us. We've given time for this to be ascertained. Nothing. Don't do anything precipitous in between.
Good deal.
From the meanness,
Better both of you elect 11s and play football against each other. Meghalaya has done very well. Reached the Santosh Trophy final, barely lost it. So
Yes, we are happy for that.
yeah. Yeah, I know, you told me before. Yes.
Good evening.
Justice Dindo remembers playing in that park from 1935.
Lordship, in fact, Honorable Justice Dingda was residing just across the field. And I happen to be born and brought up in Lomori, Lordship. And for record of this court, even Justice Thank
you is right there.
Resides in Lomori,
Right there,
Lordship.
yes.
But I was born and brought up in that place, Lordship. I know this place very well. Much obliged.
Yes.
From the main list, item number 1.
My lord, it's a traffic PIL.
Yes.
And we have taken certain steps, my lord, and if I can place, my lord, a small brief note where the various decisions have been taken, and we have taken certain steps in this regard, my lord. We have appointed the officer also for coordinating the DIG rank officer, my lord.
What about schools have reopened? What about the buses?
Schools, my lord, buses, we have started, my lord, if I can place this chart, my lord, the steps which we have taken.
We'll keep it after some time.
Yes,
you know,
sir.
because we know some steps have been taken.
Yes.
It's there to see that some steps have been taken.
Yes.
But at the end of the day, we can't go and monitor it.
And
So you have to do it to the best of your ability. What about the ropeway?
Ropeway, we will now, the act has been passed, my lords, and now government will definitely push this whole idea of ropeway. In fact, one site has already been identified before election. I have seen that proposal also, and connecting the Shillong Peak, but that will be for the purposes of tourism, my lord. Second proposal was with regard to Umiam Lake also. There also there is a proposal to have the ropeway, my lord. But I don't have the current status of the matter.
But that ropeway over Umiam Lake, if it goes over Umiam Lake, will be beautiful.
Beauty will be destroyed.
Yes. But the only one thing, it can pass, the pillars need not be constructed in the lake itself. The pillars can be constructed on the side. It will be beautiful, but no food item allowed on
Yes,
the...
Your Lord. So that order is very much there because any food item or plastics, etc., then whole place will become garbage.
Very well. Since the state says that some steps have been taken to ease the traffic congestion and a plan is being put in place, let the matter appear 4 weeks hence.
Obliged, my lord.
Much obliged. Item number 2.
Lordship,
Yes, what is this matter about?
this present arbitration appeal relates to only one claim, that is the claim relating to foreign exchange variation. It is the case of the contractor that there was an inordinate delay in execution of the work, and as a result, the price of US dollar and euro arose high. Though the original price of the commodity remained the same, but exchange value.
The price of the commodity was expressed in foreign currency?
No, it was not. It was not quoted in the foreign exchange. The contract was finalized in terms of Indian currency. All payments were in Indian currency, though he was given an option to quote for foreign exchange variation. Since he has not quoted, so related clauses dealing with the foreign exchange variation were deleted. So contractor case is this, that there was an inordinate delay and as a result, the procurement of these steel items were delayed and he suffered a loss. The tribunal has recorded the finding against me that there was a delay, and the delay is attributable to the corporations. So far, corporation case is concerned, corporation case is this, that this delay was for the region, for the unavoidable regions and over which we had no control. However, the contractor sought extension of time, and he was granted extension of time, and he was also paid escalation as per clause, related contractual clause. The learned arbitrator, Your Lordship, has not taken into consideration those clauses which restrict the claim in the event when the extension of time is granted, Your Lordship. I take to Your Lordship 2 paragraphs of the impugned award. Award starts from page 65. Page 92.
Yes.
Paragraph 5.32. From the above discussion, it is therefore evident that the claimant was responsible for delay in completion of the project beyond the stipulated time 2/3/2009, and as such, delay was attributable to the respondent. That's one finding. As discussed above, the claimant in Exhibit C30 Poli has stated the loss incurred due to foreign exchange variation while procuring the imported steel liner plates, giving the statement regarding phase-wise procurement of steel plate liner by the claimant with respect to PSC issued by the respondent, and also while procuring hydraulic cylinder from abroad. The respondent, as noticed above, has not challenged the same at all. The claimant, however, by amendment, has reduced its claim from 9.13 crores to 8.75 crores towards principal amount. The respondent claims that in view of clause 74 of the condition of contract, which provides for price adjustment variation, the claimant is not entitled to anything as against the claim number 2. Clause 74 deals with the price adjustment, price variation, which applies if there is a variation of price of the material except for those material supplied by the corporation, as well as if there is increase or decrease in the local currency, cost of labor, and in high-speed diesel. That the said clauses does not apply when the contractor suffers loss due to foreign exchange variation, as it is not the case of the claimant.
Very well. Regards to clause 74.
Yes, Lordship. Hmm? 287. Page number 287, Lordship. Price adjustment variation. Lordship, according to me, Lordship, that it is covered under 74. Payment to contractor for work done shall be adjusted for increase or decrease in the local currency, cost of labor, material, except for those material supplied by the corporation and high-speed diesel according to the procedure mentioned hereunder, and the total percentage component of these shall be 80% only. The bidder shall fill up the various components for labor, material, and high-speed diesel as per Form B, datasheet 2A of Volume 6. The base indices for price adjustment against labor, material, and high-speed diesel shall be on the day 28 days prior to the latest day for submission of the bids. Then your lordship, under this, the how to calculate the labor escalations and on material, then high speed diesel at page 289.
No, let us see material.
Material. If after the date of opening of the tender and during the currency of the contract, there is any increase or decrease in the price of material as reflected in the revised index number of the wholesale prices in India, group and subgroup average for all commodity base 1993-94 equivalent to 100, the corresponding increase or decrease in the payment of the contractor shall be made according to the following formula. And that this formula, lordship, is given. Then your lordship, I take to your lordship page 290. Clause B, under the heading General, this clause shall be applicable only for the work that is carried out within the contract period or any extended period attributed to the corporation only. Then your lordship, I also rely on clause D. No claim whatsoever for the price adjustment variation other than those stipulated above shall be entertained. That is, your lordship, one of the prohibitory clause, apart from the clause for extension of time, which is provided under clause 24 within bracket Roman 7. Lordship, I once again take to your lordship the award where we were stuck up on the last occasions, that is paragraph 5.35. 5.35. May I read your lordship?
Yes, sir. Show us the quotation. Show us the correlation between the quotation and the foreign currency price.
Your lordship, since the contract was finalized in terms of Indian currency.
No, show us the quotation. Show us his bid, where he had quoted
The bid
price.
in Indian currency.
In Indian currency.
Yes,
If there, that has any correlation with foreign currency price.
No. 1 minute, lordship.
Is 152.
152.
Foreign currency component of the bid, my lord.
152, yes.
No, your lordship, I'm sorry, your lordship. This is the subsequent bid which we have asked. There were initial bid submitted by the contractor, and after submission of the bid, at the time of submission of the bid, the process of declaring the project as a mega project was going on. Now, in mega project, contractor gets certain benefits. So we have asked all the bidders to quote alternate bids in the event the project is declared a mega project. It was in reference to that he has submitted this alternate bid, and ultimately, Your Lordship, the project was not declared as a mega project. It was declared. It was.
Where is the original bid?
Lordship will come to page 182.
182.
82. In data sheet, he has quoted the price variation adjustment to be quoted by the bidder. Bidder and each partner should provide information on their work commitment on all construction material acquired since shortlisting applications. Non-adjustable part, refer clause 74, volume 1. Adjustable part 75. So 25% were non-adjustable and 75% were adjustable. Among adjustable for the labor, he has quoted 27.5%. As regards material, he has quoted 40%. It was within his discretion. He could quote 40% for the labor or 20% for the material. That is how he is planning. Now, I read note, bidder must fill in the price variation component against labor, material, petrol, SD and lubricant in percentage. In the event of bidder not filling in any of the component, the same shall be assumed at zero and no price adjustment for the same will be applicable. All India Consumer Price Index for Industrial Worker published in RBI Bulletin. Then the last line, Your Lordship says, the price indexes for the above prior to 28 days of submission of the bid are enclosed. So this was submitted on 2/2/2004. Then, Your Lordship, in data sheet 2, he was also given an option to quote financial implication against deviation, that in the event of deviation, what will be the financial implication? He said nil. Then, Your Lordship, on page 184, also, he has quoted nil financial implications against additional clauses, if any. That in case of any additional clause that he was required to procure the material from abroad involving the foreign currency, he has stated nil. Then, Your Lordship, on data sheet 4, the schedule shall be completely filled with the estimated quarterly payment to the contractor, including estimated escalation. LC, this is all Indian currency, Your Lordship. All prices, Your Lordship, in the bid were quoted in the Indian currency, and page 186 is the bid letter. Then your lordship at page 191, he has given a warranty and clause serial number 4, the contractor accepts all risks directly or indirectly connected with the performance of the contract. Then, based upon the projection made by the contractor, we have issued him LOI. Your lordship, LOI is issued on 3/12/2004 on the basis of the bid which he has submitted on 2nd February 2004, not subsequent bid which my learned friend was trying to show. That it was in that bid he quoted involvement of the foreign currency, that if the project is declared as a mega project, then there is a requirement of foreign currency so much. But since the project was not declared mega project, we have opened the initial bids of all the bidders, and since he did not quote involvement of any foreign currency, based upon that projection, the work was allotted to him. One point, your lordship, which came up on the last occasion is paragraph 5.35 of the award at page 93. Lordship, may I read?
Mr. Kumar,
Yes, sir.
apart from that page that you showed,
Yes, sir.
which is subsequent to their letter,
Yes, sir.
and it refers to if it were to be a mega project.
Component.
Apart from that, you quoted in Indian currency only.
Yes, sir.
Where is the quotation where you reserved any right to ask for revision?
Yes, sir.
Did you ask for revision if currency fluctuation was there?
Milord, definitely no. It was not there, Milord. But the project.
But quoted the price.
Yes, Lord.
In Indian currency.
Rupee. Yes, Lord.
So therefore, why should you be entitled to? And if you are entitled to,
yes, Lord.
You'll be entitled to only in accordance with the increase in wholesale price index.
Yes, Lord. may
1993-94 being the base year,
yes, Your Lordship.
WPI, to what extent it increases, general or average?
Yes, Your Lordship. Now I have two
General meaning across the board, average meaning cement, steel. Over there, you'd find specific subgroups.
Yes, Your Lordship. I have two submissions, my Lord, on what has fallen from Your Lordship. First submission is, my Lord, this project, the contract was for a period of 51 months, my Lord. And the contract, as per the initial period, it was to end in 2009. The contract was delayed by a period of 10 years, my Lord.
10 years.
10 years. Now the learned arbitral tribunal, because on the issue of finding on the delay, they admitted that delay is on account of their part and that there has been delay. So the learned arbitral tribunal on that issue, if I take Your Lordship to the finding on that aspect, and then compensation issue, whether what is going to be the basis for adjusting the compensation, my Lord, kindly see paragraph 5.26, my Lord. At page 88 it starts, my Lord. Page 88, 5.23. It is not in dispute that the initial period of completion of contract was on 2nd March 2009. Work could not be completed till the date, resulting in ordinary delay. Work under the contract is still continuing. This is 2017 award, my Lord. Claimant, as noticed above, has claimed the foreign exchange variation under so and so, my Lord. Now 5.25. Claimant has claimed that foreign exchange variation amount contending that because of prolongation of contract, delay in finalization of design, engineering of paint stock steel liner, which led to shift of procurement of steel liner paint beyond the original contract period. The claimant has incurred loss of so and so amount, my Lord, due to devaluation of rupees vis-a-vis dollar while procuring the imported specialized steel plates, quantity of paint stock liner in phased manner, and also for delay in issuance of project authority certificate by the respondent to import such plates. The claimant, in support of the claim, has also filed the statement of loss incurred under exhibit so and so, which also indicates the statement regarding phase-wise procurement of steel plates quantity by claimant with respect to PAC issued by the respondent. It has also been pleaded by the claimant that on account of foreign exchange variation, the claimant has also incurred loss of 1,80,000 on procurement of hydraulic cylinders from abroad, as design and capacity of the hydraulic cylinders were changed by the respondent, resulting in its delay in procurement. Conversion price in 2003, that is 28 days prior to the bid opening date, so far as the relates to USD and Euro, apart from such conversion price of USD in August 2013 and Euro in May 2014, have also been pleaded. In paragraph 5.3, claimant contains that though the term for execution of the contract was 51 months, that is 2nd March 2009, the same has been delayed for the reasons attributable to respondent, and having accepted the same, respondent accordingly provisionally time extension for the contract package on a number of occasions. In paragraph 6 of the amended statement of claim, claimant has also specifically pleaded about the massive delay on the part of respondent to hand over the civil front of pen stock liner work, and also some of the fronts of the steel liner work are yet to be handed over by the respondent. It has also been pleaded that none of the civil fronts could be handed over to the respondent to the claimant within original contract period of 51 months. Claimant has also enclosed list of dates handing over steel front for pen stock liner as communicated by respondent in C4 Collie. In paragraph 7.2, the claimant has also pleaded the due exchange of design and capacity of hydraulic cylinder by the respondent. Delay was caused in procurement of hydraulic cylinder from abroad, which resulted in the loss to the claimant due to foreign exchange variation. Claimant has enclosed the statement so and so. The respondent in paragraph 3 of the amended statement filed admitted that completion of the project got delayed due to various unavoidable reasons, and as a result of which commission's schedule has been revised to March 2007. In paragraph 5, though the respondent denied the claim of claimant that the project got delayed due to reasons attributable to respondent, it has, however, admitted that extension of time has been granted to the claimant by the respondent as and when it appears to be reasonable to do so, and such extension was granted as circumstances warrant so. The respondent, in pleading while denying the claim of the applicant that reason for delay was attributable to them, has however admitted that delay was due to reasons given by claimant in paragraph 3.2 to 3.5 of the amended statement of claim. In paragraph 10 thereof, the respondent has also admitted reasons for delay in handing over the civil work for penstock liner work has been correctly stated by the claimant in paragraph 3.2 and 3.5, which according to respondent are not directly attributable to it. In paragraph 11 thereof, respondent has stated the delay as contended by claimant has occasioned by the circumstances which are beyond the scope. Now, my lord, after recording all this, my lord, in 5.29, the finding is recorded, my lord. The time for completion of project was 51 months up to 2/3/2009, which was admittedly the contract could not be completed. Respondent, based on the application filed by claimant for extension of time for execution of work required under clause 24 of the condition of contract, provisionally extended the time for completion of the contract void letters. In the said communication, reasons for extension, however, has not been mentioned. Claimant thereafter filed another application on 2nd May 2013, seeking extension of time for completion of work up to December 2016, giving reasons for such extension: delay in finalization of parameters for civic front, delay in approval of design and drawing by respondent. Said application was filed in terms of clause 20 of the condition of the contract, which provides for filing the application seeking extension of for reasons, amongst others, non-availability of working fronts for reasons attributable to the corporation, and for any other cause which is in absolute discretion of the engineer in charge in beyond the contractor's control. The respondent, based on this said application, has granted extension without challenging the ground on which such extension was asked for. It is not the case of respondent that claimant did not submit the required drawing within the time allowed under the contract. The claimant has claimed all drawings have submitted within time. The specific plea of claimant that the execution of contract involved procurement of steel liner plates and hydraulic cylinder from abroad in USD and Euro, respectively, requirement of issuance of project authority certificate by the respondent from time to time to get the exemption on excise duty for such procurement and procurement of such material from abroad have not been controverted by the respondent. As such, it is an admitted position of fact. The clause 28 of the condition of contract requires carrying out the work of the claimant in accordance with specification and drawing and order, etc. Subclause 2 binds the contractor to execute the work in every respect in conformity with the specification laid down by the engineer in charge. The contractor is also required to conform exactly, fully and faithfully to the design, damages, etc. in respect of work duly signed by engineer in charge from time to time. Therefore, when there is a delay in handing over civil front, approval of design and drawing and revision of the same by respondent, contractor has to be compensated. When such delay is not attributable to contractor, and the contractor cannot be allowed to suffer for no fault of this, my lord. So this is the finding, my lord, with respect to the fault or the delay caused by the respondent. Now, in that context, my lord, learned arbitrator is weighing or adjudging the loss caused on account of this inordinate delay of 10 years, my lord. And in my pleading, my lord, in my statement of claim, I have quoted the rate, I have quoted the rate of euro, I have quoted the rate of dollar, and that has not been denied in a statement of defense, my lord. To that extent, it has been admitted, my lord. So therefore, based on that finding, my lord, the learned arbitrator has said that, has taken a reasonable view of clause 74, my lord. And that, in my humble submission, my lord, that is a possible view taken by learned arbitrator, my lord, while construing the section 1774, my lord. And your lordship knows that now the error, even assuming without admitting, has been committed, that error is within the domain of the arbitrator, my lord. It is not akin to perversity, my lord. Because there is a 10 years delay, I have given the rate, they know that the steel liners are to be imported, hydraulic cylinders are to be imported, my lord. I have given the figures also, my lord, and based on that, my lord, the arbitrator has, and those figures have not been challenged. If I can show, my lord, my statement of claim at 401, and their reply in 40, in fact, in their reply, they said 468, my lord. What is being said by NEPCO is that this variation is very much what the reply says, that respondent states that foreign exchange variation cannot be predicted. So within contract period, my lord, I have not claimed any escalation, my lord. I have not claimed any extra amount, my lord. But beyond the delay, when admittedly delay is on their part, and loss has been caused on account of delay for purposes of calculating the loss, my lord, it is the foreign exchange variation which has been taken into account. While examining this aspect, my lord, the learned arbitrator has examined all these aspects, and reference was also given. Reference to the arbitrator was also limited to the issue, my lord, that no oral evidence will be laid. The arbitration proceeding in page 71, para 10, where is the reference is there. The arbitration proceeding shall be proceeded with for the present without requirement of witness testimony. After completion of pleading in the matter, the parties will address oral argument before the tribunal. If during the course of oral argument only dispute arise in respect of any fact or document, appropriate steps can be taken at that stage with respect to such fact and document. And my lord, before the learned arbitrator, both the parties have said that they will rely on the document of each. Now, they rely on the document of the parties, my lord, and that is also recorded by learned arbitrator while dealing with this aspect at page 73, my lord. Submission of where the learned arbitrator says, my lord, submission of both the parties that they would not adduce any oral evidence, and argument would be made on the basis of documents filed by the parties apart from the original record to be produced by respondent has also been recorded on that day, and neither of the parties dispute the document filed by them, my lord. So these documents which I have filed have not been disputed, my lord, showing that the rate of the dollar and rate of euros, my lord. Therefore, in my humble submission, my lord, this is a reasonable view, a possible view, and as your lordship is aware that the scope of Article 34, Section 34 is very narrow and limited, and admittedly there is a delay of 10 years, my lord.
Delay of
10 years. And delay is directly attributable to the petitioner.
that they have also not said anything.
So now the issue is computation, my lord. Issue is how to
computation.
Now
the issue, it has to be done in accordance with the agreement.
No, my lord. Now that
agreement.
Amendment has the Act Section 28 has been amended, my lord. Now.
Which one?
Section 28 of the Arbitration Act.
Arbitration Act, yes.
Earlier, the requirement was that it has to be strictly done in accordance with the arbitration agreement, my lord. Yes. Now the 28(3) amendment says shall take into account. So that requirement, which has been explained in Sangyong, my lord, by the Honorable Supreme Court, because this is the challenge after the amendment, my lord. So therefore, the amended Arbitration Act with Section 28(3) will apply, my lord. If your lordship takes a view that
the matrix contract provides for escalation.
Yes, lordship.
It provides a manner of escalation.
Yes, lordship.
Now, when it provides for a manner of escalation,
yes, lordship,
it has to be that manner and nothing else.
No.
So now you have to, if you have made a claim with reference to WPI,
yes, sir,
1993-94 being the base year,
yes, sir,
then your claim is permissible. But if you've not made a claim in accordance with that formula, then your claim couldn't have been looked into.
May I submit, my lord? So far as this applicability of the WPI formula is concerned, this may hold good for the contractual period, my lord.
For the
contractual period, that is 2/3/2009, my lord. Beyond contractual period, my lord, what learned arbitrator has done is that he has computed the loss for delay caused by the petitioner.
Let us see.
And kindly see Section 28(3) of the Arbitration Act.
That applies to the extended period also.
Paragraph 5.31, my lord.
No, we look at
And then your lordship will see 5.34 bottom also.
No, we'll have to look at first the contract. Payment to the contractor
Page number
for work
290,
done
my lord.
shall be adjusted for increase or decrease. So it's both ways. It's a two-way.
Yes, lordship.
According to the procedure mentioned here under, and total percentage component of these shall be 80% only. The bidder shall fill up the various component for labor, material, high-speed diesel as per Form B. The base indices for price adjustment against labor, material, high-speed shall be on the day 28 days prior to the latest date of submission of bids. So that would be the fixed.
Yes, Lord.
And any increase, labor, forget labor, if after the date of opening of tender during currency of contract, there is any increase or decrease, currency of contract, in the currency of the contract. It is not beyond the currency of the contract. Now let us see if there are any forbidding clauses, any clauses of prohibition.
In fact, my lord, kindly see page 290, 75.
$75 is not in your favor. What is in your favor is 76.
76, my lord. But I have to add one caveat, my lord. Caveat is that their case before the London arbitrator is that these two clauses have been deleted from their tender. But when the contract was signed, these two clauses were part of the tender. I raised that argument, but arbitrator has rejected my argument at page 90.
The arbitrator said that these two clauses were deleted.
These clauses, no, arbitrator has not gone into that aspect, whether deleted. Based on 74 interpretation only, money has been given to me.
Based on 74.
Yes.
$75 does not affect us.
76. And there is no bar.
76 is where the contract subject to variation rate of exchange
and admittedly paid.
And that is again on the other side. If you are being paid in foreign currency, then naturally, of course.
So the only on the issue there is no bar in the contract, my lord.
There is no bar in the contract.
Only on the issue there is no bar, and that is a possible and reasonable
There
view.
is no bar in the contract, plus the clause also provides if after the date of opening of the tender and during the currency of the contract.
Highly obliged.
So it's restricted to the currency of the contract.
Yes.
If it goes beyond the currency of the contract, which is the time originally.
What my friend is arguing, the extension is also currency of the. My humble submission is that when I submitted the bid, my lord.
Lordship, if I am permitted.
Just a second. show us your quotation in of the components of the price of material.
Yes, my lord. Page 153 is where the quotation of imported component is there, my lord.
No, 153 is not right. 153 is the mega project.
And yes, my lord. Then, my lord, if I place
Where is the original quotation?
Part of the record.
Work order.
What page?
Work order.
Page. Page 195 is the work order, my lord. And it also says the completion of work
195.
is 195 work order, my lord.
Yes.
And a scope of work is, my lord, is there.
Now, where is your price quotation?
Lord, I will place that price quotation, my lord. It should be part of the price quotation.
Part of the work.
Because let us come to the award. .32, there is no objection.
Yes, sir.
Page 92.
Yes.
Then is claimant in exhibit C13 collectively
Yes, Lord.
has stated the loss. Now, if you had quoted the price in Indian currency, how can you over here go into foreign currency?
Yes, Sir Lordship. Now, there are two.
So therefore, we have to see how you had quoted it. If you have quoted in Indian currency with a reservation that these are indicative of the current prices according to the exchange rate.
Yes, Lord.
What arbitrator says, no interference. But if that is not there,
Yes, Lord.
for instance, if you've quoted, let us say, steel at 25 rupees per ton, without saying anything about foreign price, then steel at 25 per ton, unless you can show that they asked you the bid documents required, steel of a particular grade to be obtained.
It's there, my Lord.
Where is that?
Your Lordship will
And
see.
in any event, even if it is there, the arbitrator has not referred to that.
is referred to that, my lord.
Where is that?
I will show both the parts, my lord. Kindly see, my lord, the correspondence in this regard where the reference is there.
No. First show us the arbitrators.
Yes, your lordship. Yes, your lordship. Yes, I'm sorry. Page, if your lordship will see the arguments which we have advanced. Now, there are 5 chapters of the Learned Arbitrator Award. First chapter is dealing with the appointment of arbitrator, my lord. Second is before the
Duties of the parties.
proceeding. Now, your lordship will see the one part only, page 73, 4 lines, my lord, with regard to the stand of parties before the arbitral tribunal, my lord. 5th line from the top at the page 73, my lord. Submission of both the parties that they would not adduce any oral evidence and arguments would be made on the basis of documents filed by the parties apart from the original. So this is and they will rely on.
Yes.
Then, my lord, pleadings of the parties. My claim is, my lord, on precisely on this issue. I skip that part also, my lord. Kindly see the 4th chapter discussion part. The chapter number 4, my lord.
Submission.
Yes, my lord. Now 4.5, my lord. Insofar as claim number 2 is concerned, it has been submitted by learned counsel to the claimant that claimant has incurred so and so, valuation so and so, in delay in final design engineering of pen stock liner work, which ultimately resulted in reschedule of procurement of steel liner plates from abroad beyond the original contract period, which delay is attributable to the respondent. Claimant accordingly learned counsel devalue now hydraulic cylinder. Learned counsel for the aforesaid claim submit that there being no dispute of few components of contract are to be imported from abroad. And the claimant, while later dated 21st April, having declared that they would be importing various components so and so, the claimant is entitled to foreign exchange variation attributable to the learned counsel in this regard has also referred to the conversion rate of US dollar in 2003 and such conversion rate during the original contract period subsequent thereto demonstrated because of delay attributable to respondent, the claimant had to pay much more at the time of actual procurement of those components from abroad. What they would have paid if there was no delay on the part of respondent in final design, engineering of pen stock liner work, and also because of change in design and capacity of hydraulic cylinder. The learned counsel, referring to the clause 74 of the condition, which speaks about price and variation, also submit the refusal.
No, we understand that.
Yes, your lordship.
Where does the contract specify that these material have to be procured from abroad? And where does the contract specify that steel liner plates?
Yes, lordship.
Come to 4.5.
Yes.
These two you show and you're through.
I'll show, man. I have that, my lord.
In reschedule of procurement of steel liner plates from abroad.
Yes, lordship.
Show us that the contract required a particular thing from abroad. Also, you come to 3 lines below.
Yes.
Procurement of hydraulic cylinders from abroad.
Yes, my lord.
Show us that this required. Show us the contract. That
Yes, my lord. I have that. I have seen it, my lord. I will place it, my lord. This part I will place.
Once you show it,
I'll place it. I'll place it, my lord.
Because even though reasons are not there,
I will show the reasons are also there, my lord.
Where show us
that part also. Your lordship will see. Now discussion 5. Your lordship will see the discussion of the learned arbitrator because
up to 5.32 we give it to you.
Yes, to 5. No, 5 is the conclusion, my lord. Kindly see because in all cases, my lord, we are.
Where is that?
Yes, 5.25.
5.25.
And then your lordship 89, page 89, my lord.
This is the claim.
No, this is the claim. Now kindly see 4th line.
Where is the justification?
Yes, while procuring the imported specialized steel plates, quantity of pen stock liner in phased manner, and also to issue project authority certificate. So the project authority.
Where is the satisfaction of the arbitrator that you had to? This is what you had actually done. Where is the satisfaction of the arbitrator that this was required to be done by the contract?
On this part, my lord.
Exactly.
I'll
For instance, I'm supposed to supply steel.
Yes, lordship.
I can get steel from Steel India Limited.
Yes,
I can get steel from Tata Steel.
Yes,
I can get steel from Ukraine company.
Yes, lord. I got it, my lord. I have to show this much only and
only that much you have to show.
Yes,
because we have very limited
I bow down, my lord. I will place that part, my lord. I will place that part.
Tomorrow?
Tomorrow, yes. You have the original.
a big document, you have big document and every entire contract data.
Come on. At the request of the respondent, let the matter stand over for the day. Yes.
Complete.
Item number 3.
May we please, Your Lordship? Your Lordship, I beg to seek an adjournment as the conducting counsel is on leave, Your Lordship.
Yes.
Your Lordship, I beg to seek 2 weeks' time, Your Lordship, as the conducting counsel is on leave, Your Lordship. Mr. S.P. Manta.
Since the appellant seeks further time, let the matter appear fortnight, Mr. Yes.
Highly obliged, Your Lordship.
Item number 4.
Worship, this is a state appeal against acquittal. So, rare occasion for state to stand on the other side.
Sorry?
It's a rare occasion for the state, normally we
Yes.
defend. And so, Worship, the limited issue involved here is factually the situation is few school friends. They were very good friends and close friends. And it so happened that there was some issue regarding money issue. And among each other, they decided that how to earn money. And one of them hatched a conspiracy. It did not take off. And something failed. So then what happened on a given day, on 19 February 2006, on a given day, they met at Police Bazaar. And they had the drinks. And from there, they went to Polo. From Polo, they went to, there's a graveyard near Maulai, after FCI, Your Lordship. So the crucial evidence, Your Lordship, is that the rickshaw puller, who's also a witness, has deposed in the court that yes, they travelled together. And then the victim doesn't come back home. And next day, there's a guardian who was taking care of this boy, the victim, was informed by other colleagues that he has gone missing, immediately files an FIR. And they get some lead. And then they go to the PO and realize that they dug a body out. Body was dug. And the murder weapon was a rope, which was discovered at the behest of one of the accused. That is an evidence. And there is no other murder weapon other than the rope. Rope was discovered at the behest of the accused. Both the accused, Lordship, sorry, there were 3 accused. One accused was discharged because there was no evidence against him. So the 2 accused made a statement in 164.
2 accused?
2 accused made a statement, 164.
Yes.
That is where the law part comes in, Lordship. 164 statement was recorded by the magistrate. One of the accused clearly in 164 has arrayed the other accused, saying that he strangled with the rope. Whereas the other accused slightly wavered, but not very clearly saying that he had caused the death. But both of them, at least, there is evidence to show that rope was used, body was recovered, and they had confessed before the magistrate. Now, very, very important issue, Lordship, from here, the important legal issue is if 164 was not retracted, number one. Number two, the magistrate who recorded the statement, PW 32, she appeared in the witness box. She exactly stated in the in-chief all the details as to how she had recorded the statement. In the cross, there is no whisper. Rather, it affirms that the statement was recorded. And there is no whisper that the procedure of 281 was not followed. This is not the case of on oath, so we don't have the problem of oath. And other legalities was not questioned. So rather, it is affirmed. Now, when the prosecution witnesses stage was over, opportunity was given to the defense to lead evidence. They chose not to. So Lordship is aware that when you choose not to, then the only small window that remains open to you is under 313. Now in 313, Your Lordship, specifically there are 6-7 questions put to the accused, both the accused.
Both in respect of PW 32 also.
PW 32, Your Lordship, I'll come to it in detail. I'm just trying to assist the court, Your Lordship, so that it's quite elaborate evidence. But these are the main 164. And so what happened, Lordship, in 313? Number of questions were put, they all denied. And so far, one very important statement was put to the accused was whether these three statement was recorded. He just said he came to the witness box, he was there whole day, and eventually he was made to sign and he left. But that is palpably incorrect statement, Your Lordship. Why? Because that contradicts exactly what the defense did in the cross. In the cross, it is affirmed. But only minor variation is there on the date, 8, 9 or one date, because the magistrate has signed.
What is the reason given by the trial judge in disbelieving the 164?
Lordship, that is the crux. That is where the whole judgment, he says he's relied on section 30 of the Evidence Act. Section 30 says when one of the co-accused confesses, it also implicates the other co-accused.
Yes.
Because Myra, Lordship, it was not a variation on substance. Let me admit, Your Lordship, it's not a variation on substance. The minor variation, trial court judge said that we cannot rely on.
There was a 34 charge.
34 charge was
there. There was a 34
yes,
charge.
302, 34 charge. And the trial judge said 164 because there's a contradiction, not clinching. He has not gone to the part that 164 itself suffers from inherent flaw. That would have been a different case, Your Lordship. Inherent in the recording itself and other things were not complied. It could not have been correct. But he's gone to the merit of 164 and says it is not proper.
We will, ready? We'll finish it off.
Yes, ma'am.
So in nutshell, Your Lordship, though we have got two major paperbooks, Your Lordship, but this is the legal issue that the trial court judges relied. 164 not retracted. First opportunity for defense to bring witness was they chose to remain silent. In 313, an attempt was made to say he was there in the courtroom. But no statement was recorded. Now that directly contradicts when his defense lawyer cross-examined PW 32. So in other words, Your Lordship, 164.
Just bring us straight to the 164.
Lordship, yes. Lordship, paper book 2. Page 499, Your Lordship. Four 449, Lordship.
Sorry, 449.
449.
Yes.
Lordship will take your Lordship to the type copy. Type copy is that it starts from 457. Lordship, first if we can just come to 458, the clause number 5. With the requirement of 164 was complied on. 458, this is the type copy. 5 says, I now carefully explain afresh to the accused that I am not an officer or police but a magistrate, that he is not bound to make a confession, that he should not say anything because others have told him to say, but he is at liberty to say whenever he desires to say, that he should say nothing which is untrue. So all this requirement of 164, mandatory requirement, Your Lordship, was done. Now, Lordship, if we come to page 461 is the statement recorded, Lordship. 461.
Where is Bonnie's?
475, Your Lordship. That copy is at 475.
Postmortem report?
Lordship, Lordship, before that, if it come first to inquest, which is at 413.
413.
413, Your Lordship.
When was the dead body recovered? When was the incident? When was the dead body recovered?
Incident in Lordship is of 19/2/2006.
And exhumed 21/2.
21/2. Lordship, the injuries part, that is very important, Your Lordship.
Just a second. $30.2 for Bonnie, $201 for both.
Lordship, you may submit because the inquest report is very important.
There's no contradiction.
Lordship, I'll just.
There's no contradiction.
Lordship, inquest report is fully corroborated in the postmortem.
With the postmortem?
And Lordship, if I just take your Lordship to page 426.
Where are they? They are both at large, they are available.
Yes, ma'am.
Yes, my lord. In fact, your lordship had passed an order that they are to, in case they leave the state or if they leave the city, they are supposed to report to the police station concerned.
Are you ready to proceed straight away? Because prima facie we are going to convict you.
My lord, before that, we may be
No,
given an
actually we'll
opportunity.
hear you.
There are some maintainability aspects, and the second thing is-
Maintainability aspect?
Yes, my lord.
What maintainability aspect?
Maintainability as regards the filing of this appeal. In fact, this appeal has not been filed by following the statutory provisions of law, my lord. And I have supporting notifications as well as
What
the
statutory provisions?
My lord, if I may take your lordships to section 378 of CRPC, my lord.
Yes.
My lord, 378 is appeal in case of acquittal.
Yes.
Save as otherwise provided in subsection 2 and subject to the provisions of subsections 3 and 5. Number A, the district magistrate may in any case direct the public prosecutor to present an appeal to the court of session from an order of acquittal passed by a magistrate in respect of a cognizable and non-bailable offence. State government may in any case direct the public prosecutor to present an appeal to the High Court from an original or appellate order of an acquittal passed by any court other than a High Court, not being an order under clause A, or an order of acquittal passed by the Court of Session in revision.
But how does 378 apply over
My
here?
lord, yes, 378 does apply.
How does 378 apply?
My lord, because this particular incident, this took place from Police Bazaar. Police Bazaar does not fall under an
Not
autonomous...
Police Bazaar. It took place in Mauro.
My lord, the cause of action arose in Police Bazaar because the PW5, Nirvika Singhania, the FIR was lodged.
That's not
My
the
lord,
place of incident where the body was exhumed.
this case-
Was Mauro.
My lord, exhumation is there, but if I may humbly submit...
Even if it is Police Bazaar, CRPC had not been notified over here. Ever.
No, my lord, CRPC has... It's a normal area, so it applies, my lord.
Police Bazaar is within the
Yes, my lord. Within CRPC.
European ward.
Yes, my lord. And second thing, my lord, this, like in the trial court out here, we have a division between the cases. Sessions case, number, so and so. If it is a T within the bracket, it means that it falls under the autonomous area. But if there is no T, then it falls
So what
under
is the
normal
infraction?
area.
What according to you is the infraction?
Yes, my lord. I'm coming to that, my lord. My lord, section 378 provides two important aspects which need to be followed while presenting an appeal before the High Court. The first is the public prosecutor needs to present the appeal. Secondly, an application, if I may take your lordship to subsection 3 of section 378. No appeal to the High Court under subsection 1 or subsection 2 shall be entertained except with the leave of the High Court. Now, my lord, when this particular appeal has been filed, firstly, there has been an infraction of subsection 3. That is, there was no leave application filed before this honorable court. Secondly, my lord, if I may take your lordships to the memo of appeal, my lord, at volume 2, my lord, of the paper book, page number 555, it starts, my lord, the appeal.
Yes.
And my lord, the cause title, or even if, yes, my lord, the cause title which is at page 556. My lord, the cause title says, State of Meghalaya represented by the investigating officer, Sadar PS case number so and so. My lord, as soon as the charge sheet is laid before the trial court,
He is finished.
he is just a witness. Along with this appeal, an application for condonation of delay was also filed. Now, my lord, along with the condonation of delay application also, there was no authorization letter whereby the state government has authorized the IO to file an appeal, my lord. So, IO is not a competent person to represent the state government before this honorable court.
When was the order passed?
My lord, the condonation of delay, my lord.
No. When was the order passed,
The
order of acquittal.
impugned judgment, my lord,
Impugned.
that was 2019, March 2019, 26/3/2019. And this,
The appeal was admitted.
my lord, appeal was admitted, but then, my lord, if I may humbly submit just one small, but one aspect is there. The day when this condonation application was allowed, the courts were functioning in virtual mode, and since your lordship was inclined towards allowing the delay, my lord, the learned advocate general had appeared in the condonation of delay application, and a submission was made that there is a delay of merely 100 days, effectively 100 days. Whereas, my lord, in the condonation of delay application itself, I had filed an affidavit, my lord, and in the affidavit at paragraph 5, my lord, I had categorically stated that the judgment was passed on 26/3/19. The period of limitation to prefer the appeal expired on 24/6/2019.
That is all covered by the lockdown period.
No, my lord. The lockdown period started from 15th of March 2020, my lord.
Yes.
So it does not cover. 26/3/19.
Anyway, these are points of
These
no.
are- these are-
All these points that you say is that
these
we'll
are not-
regularize them. We'll regularize them.
My lord, one more aspect.
Look into it. Ask for more condonation. We'll condone delay of 10 years. We won't let a murderer go scot-free on technical
Yes,
arguments.
I'm not pressing on the condonation, my lord. But so far as maintainability, there is one more aspect to it, my lord.
You should have taken the maintainability point at the outset.
My lord, after the appeal was admitted, today is the first time the
No,
matter
at
is
the
being
time,
heard.
at the time of the appeal being admitted, you should have taken the point.
My lord, delay was condoned and appeal was directly admitted. There was no hearing on the merits of the matter or anything.
There is no
my lord.
question of hearing. You were represented then.
My lord, in the condonation I was represented.
So in the
Thereafter-
condonation, you should have taken a point of maintainability.
My lord, 378, I have... My
Sir,
lord,
madam, we don't leave murderers on technical grounds.
on technical grounds, I will not press.
This is clear murder.
My lord, I will not press on it. But even on merits, my lord, I can satisfy your lordship.
On merits, we'll hear you.
Yes, my lord.
On merits, we'll hear you.
My lord, just one humble submission, my lord, that these points which have been raised today, it is very, very true that this has been going on since a long period of time before the High Court. But there is no law laid down by this honorable court, and in almost every appeal preferred by the state is represented by IO, who is a nobody. And secondly, my lord, section 24 of the CRPC, it provides as to how the public prosecutors or additional PP or APP are supposed to be appointed. Section 24, my lord, categorically states that if PP additional...
They are all appointed in consultation with the High
In
Court.
consultation with High Court. My lord, in this case, my lord, the certificate which has been annexed with the memo of appeal, that has been signed by the government pleader who has not been appointed under section 24 of the CRPC.
Government pleader is on the civil side.
On the civil side, my lord, that is what, my lord. Section 24 has not been complied with. There is no assistant public prosecutor in the High Court of Meghalaya.
They'll take care of that, yes.
So, my lord, these things will finally be taken care of.
These points are not worthy
My lord, these
to
are
let
just
a murderer go free.
my lord,
Yes, take care of these aspects. Ask for condonation once again. 1,000 days also will condone.
my lord, no, it has already been condoned and I don't object to it, my lord.
The condonation will have, when the irregularities are removed, condonation will take effect then. So even now they're in the delay period.
My lord.
That
My lord, delay has
on merits we will hear you, madam.
Yes, my lord.
Technicalities
Merits
we are
also
very,
the chain
very.
of circumstances, the exculpatory confession, and the power of this honorable court to interfere in a case of where the accused has already been acquitted for the past more than 4 years, my lord. Now it's 4 years, and he's leading a normal life, my lord.
Let him. We'll go back to
My
jail.
lord.
We'll go
So
back to jail.
I will only argue on merits, but these are points, my lord, which require
Yes,
necessary
just see if there's any
attention.
merit in this. Deal with it. Whatever you think is necessary, we can't advise you. Whatever you think is necessary to regularize it, and please ensure, since you are the designated public prosecutor,
Absolutely, Lordship. That's why I'm doing this.
please ensure that IOs don't file it. We don't look at it, but they have to be authorized by the state, and it's the public prosecutor who's the only person who can do it.
Absolutely, Lordship.
At the High Court level. IOs can't file. IOs are finished the moment 178 is over.
Absolutely, Lordship. And Your Lordship, this matter was moved by the Advocate General as rightly submitted during this COVID period. So the highest law officer were represented in the case. It was not the case that any. So that take care of everything, Your Lordship. And now, as in the time of hearing, the public prosecutor is appearing.
No, but your appointment has not been done in accordance with law,
Lordship, my appointment has been done in consultation with the High Court.
in consultation.
Absolutely.
Yes,
Lordship. There's a notification. I'm the.
It is a 2017 notification. I have it with me. At that point of time, Honorable Mr. Justice Maheshwari was here, and it was at that point of time that the Section 24 thing came.
First time,
Until that time, there was no PP in the High Court, my lord. Sir is the first person to be appointed as PP.
So government has sent few names, Lordship, and then the High Court, 5 names was sent, and the High Court took a
We'll
call.
see if there's anything that requires to be looked into.
Lordship,
Because technicalities,
absolutely, Lordship.
whatever she says on merits, we'll look into it, but technicalities not. Some technical objections have been raised at a belated stage on behalf of
Respondent number 2.
respondent number 2, pertaining to the very competence of the appeal, as the cause title reveals that the state of Meghalaya is represented by the investigating officer who, technically, becomes functus officio upon the charge sheet being filed. Full stop. Paragraph, the state should look into the points of irregularity raised and take appropriate steps, if necessary. Full stop. The matter will appear a fortnight hence.
Deeply obliged.
Obliged, Lordship.
Now, first tell us, madam,
My lord.
between Bonnie and Bernard, who is the uncle and who is the nephew?
My lord, that is the main thing.
Both of them call each other uncle.
No, my lord. What has happened is the Section 164 statement which was recorded, my lord, this was recorded in Khasi. And the concerned magistrate who was recording the statement herself translated the entire statement in English. So, we cannot rely on such translation also, my lord.
The Khasi recording is not there.
No, my lord. It's not there.
The Khasi recording is there.
Khasi recording is there.
It's not a part of the paper book, my lord.
You're talking about 164 313?
164.
164, Lordship, everything is in English.
It is in English.
164, she is written in English.
Yes, my lord. And it is a
313.
translated copy which has been recorded in the exhibit, that it was taken in Khasi and thereby translated by me. So, my lord, now how do we respond? In fact, I personally also do not have any instructions as to whether the two accused persons are even related.
Now, those
should have been raised.
are things that you should have
Raised in the
pointed out at the time of cross-examination.
My lord, the trial...
Cross-examination,
my lord.
matter of fact. These are not argument.
My lord, the depositions, I have gone through every single deposition and I have compared the typed copy with the original copy also. If your lordship remembers...
No. You have to raise it in the cross-examination.
The entire chain of circumstances...
Did you raise it in cross-examining PW 32?
No.
You're so full of what you're saying that you don't listen to the court.
I apologize, my lord.
During the cross-examination of PW 32, did you raise these issues?
I will recheck on that part, my lord.
Because if you have not, then you're stopped.
They haven't.
I will recheck on that, my lord. But so far as
Because these are not questions of fact. These are not questions of argument. These are questions of fact.
Yes, my lord.
Because when a magistrate, is this a judicial magistrate or a
Yes,
Yes,
ma'am.
judicial magistrate.
judicial magistrate?
Judicial.
When a judicial magistrate says that I've read over and explained this to him, and then a person appends the signature, unless you establish that the judicial magistrate had some motive, we generally do not attribute motive because we are in a position we are judging.
Yes, my lord.
So therefore that judicial magistrate, unless she had an axe to grind against your client, why would she attribute a
Definitely
statement?
not, my lord. Definitely not.
So therefore, those are things that we gloss over.
My lord.
But if there is there could be exceptions, then you have to make out that exception by running a positive case.
Lord, in
That positive case you have to either in course of your cross-examination
my lord.
by giving suggestions or by adducing evidence.
My lord.
Lord Shawal, not only that they didn't adduce evidence, they missed the cross-examination. They chose to remain silent in defense witnesses. And the final opportunity, Lordship, was 313. In 313, a specific question was asked, do you have to say anything before? And still they chose nothing. And there were 5 questions on PW 32. They just said, I don't know.
look at this aspect, madam,
shall
because
aspect-
look at this aspect
three
because
opportunity where-
what appears to us,
Ma'am.
what appears to us is that Bernard says that he had gone, and Bernard says that when he came back, he saw that Bonnie had tied his neck with a plastic rope.
My lord.
And so this is what he says. What Bonnie says is that Bernard had gone and he lay in my lap and I realized that he was not,
died at that point of time.
he was dead. And then comes the clinching factor.
That is what, my lord. Here comes the exculpatory confession.
After that comes the clinching factor. Bernard said, I quickly took off his shoes, rubbed his sole, and did not find any sign of life, which Bonnie corroborates that Bernard even took off his shoes and rubbed his soles. So that part is the same. Once that part is the same,
Nothing remains.
everything has to be accepted.
My lord, the depositions will clear that. Because since it's an appeal against acquittal, the scope is a little bit
In fact,
lesser.
my lord, the
In fact, lesser, my lord.
the date of the death of the victim also is, my lord, not
It is
exactly
not.
proved.
It is not going with it. The post-mortem report, it says that the victim died approximately 48 hours ago.
If we find the least doubt, you're entitled to the benefit of that.
Much obliged.
You're entitled to the benefit of that. But to the way that the
Yes,
public
ma'am,
prosecutor has
understood.
put it, that only because of 164 statement being disregarded, we don't see how this 164
Exactly.
could have been disregarded without there being any external factor.
Indeed, my lord. And
If you
we-
go only by 164, open and shut.
Absolutely.
In fact, if we go by the judgment, my lord, the judgment is very, very elaborate and
have
it has
dealt with it.
It has dealt with every single aspect of the matter. Every single aspect, my lord. The entire judgment, it's a really lengthy judgment crossing over 100 paragraphs. And my lord, every single aspect.
When you
has
write
been-
rubbish, you write a lot.
No, my lord. My lord, in my humble submission, in this judgment, the law has also been discussed and how and in
I
what
can also
manner.
discuss law. Over 20 pages,
No,
I'll
no, my
discuss
lord. My lord, the
the basic
second-
structure of the constitution.
The second aspect in the judgment is the factually how this particular statement is not going
How
towards
can you
conviction.
go into facts when you have a confession?
That is the law.
Confession
Evidence
is-
Act says
Once-
admission is the best form of proof. When you have confession, how can you look at other facts?
My lord, in my humble submission, section 164 statement, my lord, it is not a substantive piece of evidence. It requires corroboration.
There is corroboration otherwise. Anyway, you come back, we'll see.
My lord.
Over.
Yes, ma'am.
Yes.
From the main list, item number 1.
But
What is this matter, Mr.?
these are those CMG University matters, my lord. The main matter regarding dissolution of the university is still pending in Supreme Court, my lord.
Very well. Since the matter pending before the Supreme Court has not yet been disposed of, let this petition appear 8 weeks hence.
My lord.
My lord, if I may submit. My lord, the University Grants Commission,
Yes.
like I was just checking the cause list on Saturday. So I have been appointed as panel advocate before the Guwahati High Court for the UGC. So I sought instructions from the legal cell of UGC, and since in these matters nobody is representing the UGC, so I have verbal instructions to enter appearance on behalf of UGC in item numbers 1, 5 and 7. They are parties in item numbers 1, 5 and 7.
In 1, 5 and 7,
My lord,
record her presence for UGC.
Yes, my lord, for UGC. And
But
I
the
shall
matter
file
cannot-
Wakalatnama in due course, my lord.
Yes,
It's
and the
in-
matter cannot be taken up because of the thing. Apprise us if we can dispose of the matter notwithstanding the pendants.
My lord, I will take some time because I don't have any records of these cases.
8 weeks. We are adjourning for 8
My
weeks.
lord.
Yes, call on the next matter,
You're
please.
obliged, my lord.
1, 5 and 7. Other matters don't enter her name.
Not all these matters.
All these are one single matter.
No,
My lord, these are connected in some way.
Okay.
Main matters item 2, my lord.
Okay, so same order in all matters.
Some are by the students, my lord, who wants their degree to graduate.
So same order in all matters except 1, 5 and 7 where we record her
name to
presence
be
for
recorded.
UGC.
You're obliged.
Connected which side? Connection होगा? Keep the file properly.